Lady Yinka, welcome on board.
Collins, thank you. Good evening, house. Good evening, house. Testing, testing.
Newton.
Oh, thank you. I just want to be sure that people are hearing what others are hearing. Everything is just too cool. Hope our day went well, oh.
So, good evening, distinguished colleagues. I trust our day went well so far. So, just a brief one before Prof comes in. So, I and Prof we have been talking about the materials for this course, and there are some articles Prof wrote which I'm still trying to get from someone who told me to meet at the faculty. So I met with the person, and the person has not sorted it out yet. So that's the reason why I've not been able to send the article yet. But however, I sent two other ones that I've actually posted on the platform, and he also said we should read, conflict of law materials from Professor Agbede and Morris, like I had rightly posted on our platform. So I know that our exams are very fast approaching, and I want us to be able to get this material so that we can actually commence our tutorials, because I know I don't want it to look like an eggshell that we're just coming to street pass questions without having deep knowledge of what we want to do or what we want to discuss or how to answer the questions. So it's this materials that can actually widen our scope. And when we meet for our tutorials, we'll be able to do the analysis of them. My thoughts, though, I may be wrong. So I'm trying to push for the materials so that unfailingly on Sunday, if you are able to get material like as soon as possible, right? Failingly on Sunday evening, we should be able to start our tutorials, right? Like my thinking is just my thinking, you know. So I know some of us are lost in this course, and I'm going to tell Prof too. We also need a revision class just to, you know, retreat um questions, areas we don't really understand, what he actually wants from us in the exam, or because that's very important, you know. So for me, I really don't know what Prof wants yet. I don't know if Dr. Falade knows, but I presume he should know. I
Because I'm
presume
the
that.
younger brother to Prof. Abi.
Yeah, yeah,
class
yeah, the
governor,
doctor.
class governor, no, no. Na Dr. Falade go no. Ah, as how?
Yeah, the You should be able to treat all those questions on global problems of this one with us, So,
Yeah.
so it's good we start our tutorial on time. So let's try to browse online. Before the weekends, I should be able to get some aside the materials I'm planning to get with Prof to look at write-offs in relation to conflict of law written by popular scholars like Morris and all, right? So that could actually help us in um in our in our exams, right? Treating it in line with the past questions I've actually looked at the past question and I was like, is it that we have not gotten to this topic? So I know some of us have read, right? So it's a time for us to share knowledge when the time comes. So so I just said let me briefly update us on that. So hopefully once Prof I'm able to get those materials from Prof, I'll share it as quick as possible. And so we could schedule a tutorial for Sunday, if I'm not mistaken. Right. So may God help us. Thank you.
Thank you, Kosher. Please, good evening, everyone. The materials you posted, did you just post them today? You mentioned that you forwarded some materials to the group. I wanted to please confirm that. Thank you. Or you sent it before now? Because at some point I had a problem with my phone, so I don't know if you had sent it before now. I don't have it. If you could resend, but if it's that you just sent it now, so I could just look through. Thank you.
Oh, thank you. Thank you for that. I posted it earlier yesterday, but I don't mind resharing it now. It wouldn't cost me anything to do that. So I'll do that right now. I'll reshare it to the platform.
Thank you.
Yeah, you're welcome. Dr. Faladesa, I don't know if doctor is with us. Yeah, they've actually, I think,
Good evening, course rep.
yeah, good evening, ma. Good evening,
Please,
ma.
good evening, sir. Please, I requested for the recording of last week. I didn't get
Yeah,
response.
yes. The thing is, since last week, I've been trying to liaise with the person in charge of that record. Even me too. I wasn't very constant in class last week. I was in a meeting, so I sent him several messages, several calls. So I had to tell Prof, yeah, to call him directly so that we could have access to the recording so he could share it with us. And Prof said, okay, we'll do that. So I'm still doing follow up on that so as to. But there's another person who does the recording by YouTube. I don't mind if the person can share pending the time we get the one from the Zoom. I know there's someone who used to do the recording by YouTube. Um, if I scroll, I'll be able to find out a colleague of us who do that. But for the meantime, I've been liaising and we get it soonest.
Thank you.
Well, nobody does it on YouTube. The class just streams on YouTube. But last week, it wasn't streaming because nobody signed into the YouTube stream. So that's why you couldn't get the stream. So it's okay to just ask them to send us the recording.
So what do we need to do are we supposed to sign in?
Yes, whoever has the handle should sign in. Once he signs in, everybody will be able to access the YouTube from even the class. Yeah.
Oh wow, interesting. Okay. Well, okay. Like anyone who has the handle can please kindly sign in, please.
No,
Yes.
nobody has the handle. It's either you or the that lady in the LLM class or whoever sets up this WhatsApp. what's it called?
Ah,
This Zoom. If you
because
look up on your screen, you see sign in. Once they sign in, we'll be able to see the streaming of the class.
oh, okay, no problem. Thanks for the information. Thanks for the information. So, I've actually messaged the person who set up the class. A response. So basically, we have outstanding groups that have not presented. According to Prof, he said he's going to continue with the explanation of Roval today, and this group presented on Roval. That's group 10. So today we should be having presentation on group 9, group 11, and group 12. And for 13 and 14 is on marriage, but Prof is still contemplating whether we are going to take it this semester or next. But if you can convince him that we should take it next semester, so that all these ones we've done, we can
Sorry,
really.
class governor. I think Prof said he was going to postpone
next
thought
semester.
and marriage till next semester. Thought and
He's
Yes,
going
marriage.
to what?
You know, marriage has issues very well. Marriage is always conflicting. We've not understand conflict of law. You want to now bring in marriage into it. Please, let's
I
push
think
marriage to
Prof
next
has
semester.
already said thought and marriage will be next semester.
Okay, so I second you, sir.
Governor can still confirm that. He said it earlier that if we don't have time, thought and something will be next semester. He said it's even better next. So governor should work on him to remind him and let him do it next semester for us.
Thought. According to what I have here, I know we have marriage, group 12, personal connecting factors. So I'm trying to look for where thought is, because the next topic we are supposed to go to is the exclusion of otherwise applicable foreign law. That's the next topic. And after that topic, that's when we now have personal connecting factors. That's for group 12. Then before we now have marriage. So I think his only marriage I heard is going to postpone to next semester. And he said those that are presenting on that will know how to go about it. So if doctor is saying thoughts, I'm trying to figure it out from the list I have here. But there's no thoughts here. Marriage, there's no thoughts here. So I think it's marriage. Except if I'm wrong, if any other person can corroborate what doctor has said. But I know for marriage, he was saying that maybe we should take it to next semester. Yeah, So, but for thought, you only have personal connecting factor before the last topic, which is marriage.
Hi,
The one we are
Pastor.
supposed.
Good evening. I just wanted to add that, yes, I remember the lecturer saying that thoughts will be taken next semester, because he mentioned that it's quite, I don't know, technical or bulky. I know he used one of those words, and he said it will be taken next semester. But for marriage, I'm not certain, but I remember thoughts. Thank you.
Okay, thank you. I'm looking at from group 1 to group 14 topics now. Which group is supposed to present on thoughts? Is there any group that is supposed to present on thoughts? Because ordinarily thoughts should be next semester. So I don't think there's any group that is presenting on thoughts. We have only 14 groups, and 2 groups, 13 and 14, are presenting on marriage. while group 12 is presenting on personal connecting factor. Then group 11 is presenting on exclusion or otherwise applicable foreign law. Yes. Then 9 is also doing exclusion or otherwise applicable foreign law. Okay. No problem. No problem. So Mr. Mr. Joero, Mr. Joero, before you came in, you were saying that you and Prof, you will be the one to coordinate the tutorial that we'll be having on this course. You and Dr. Falade. So hopefully once you get them. You said what?
Who said Dr. Falade?
Who said Dr. Falade? Where did I consent to that?
Thank you. I don't know. I think I'm starting to hear Arabic here.
It just consents. We have nominated both of you.
I think my network is bad. My network is bad. I can't hear anything again. My network is bad.
But sir, you're a doctor.
Dr. Falade, you are capable, sir.
My network is bad, though. He's somebody that has read, that can coordinate to
disability.
Don't let me come
and take a copy.
We put it to you that you have read. Please.
No, I have not. I have not read. I know what I'm saying.
We are appointing you because we are well read. Doctor or whatever.
I am a doctor of insurance and risk management, not law. So I'm learning. I'm learning. I am learning
doctor.
Here.
We don't want to know which one. Doctor is doctor. Please. Dr. Falade.
You have PhD.
My network is bad. My network is bad.
Get this PhD
properly. I can't hear people.
Dr. Falade, you have to present. You have to.
Network
you
is bad.
Can we have the attendance sheet?
Network. Hello, network.
So we can sign our attendance, please.
Class rep. Let me draw your agenda bias. Why are you picking to? Is there no equality? Why are you picking to women? Are there no ladies in the class?
Thank you
for the women.
Gender bias.
We will support Joero and a lady. Joero and a lady.
No, me. I have legal disability.
Do I have anything? You have legal disability. I have everything disability.
The thing is, who is actually moderating this whole thing? Why is everyone?
Is governor. He's governor. Governor wants to push responsibility.
At least we should wait, let someone moderate it. Cost rep, you are here, right?
Yes.
Kindly moderate the whole thing.
Cost rep.
Doctor, you know play what is for?
Hello, good evening.
Good evening.
Good evening, cost rep.
No, I'm not the cost rep, please.
Okay. Good evening, assistant
the tutorial we are talking about, when is it coming up?
We have a volunteer. Now. Thank God.
It's just a question. When is the tutorial
volunteering?
Mr. Labode, please, we appoint you to coordinate it.
When is the tutorial coming up? It's a question, not a
Whenever you want us to attend, we will all attend.
I actually have a suggestion.
Go ahead, sir.
Yes, sir. Please go ahead,
since we're not having the tutorial immediately, I support the idea of nominating Dr. Joero and even the class governor, so that they can prepare. They have enough time to prepare for the tutorial. It's not like we're having it today. So that's what I'm saying, that they will still have enough time. It is true that they might not have read, but there's still enough time for them to read. So if you're having it
what about you? Don't you have enough time to read? What about you? Don't you have enough time to read?
See the way he started beautifully. He started very beautifully and has spoiled everything.
Themselves. You could see the way Dr. Falade engaged Prof last was it last week or upper week? Yeah, I think he did justice to his paper.
I think Prof is online. Oh.
Yes, I'm online. I was even wondering whether it is the tutorial you people will do today and allow me to rest. I'm just coming from an inaugural lecture of a neighbor.
Good evening, Prof.
Good evening, sir.
Good evening, everyone.
Good evening, Prof.
Yes.
Good evening, sir.
Yeah. So, I was to explain Ruvu, Abi.
Yes, sir. Yeah, so
explain Ruvu and then move forward.
Yes, then we move to
what did we do at the beginning of the semester that when we have only 1 or 2 weeks more, we are still in somehow in limbo?
Sir, it's sign that
if we finish today's lecture, if we finish Ruvu, we'll do exclusion of otherwise applicable foreign law, and we'll do domicile.
The conflict of the process techniques. Okay, personal connecting factor, domicile, yes, sir.
Yes.
Yeah. Then marriage will be next semester.
Let me use not more than 15 minutes to explain the presentation of Ruvu, and I think the presentation was perfect. The only thing is that, as is usually tough, the presenter did not. I don't think the presenter looked at the case law, okay, on the matter. But let us even understand the options. What do we mean by Ruvu? We have been talking about lex fori, lex cosi. Lex fori means foreign law. Lex cosi means the applicable foreign law. Okay? Now, when you characterize and you get to the connecting factor, and the connecting factor points to a foreign law, the next question is, what do we mean by lex cosia? What do we mean by foreign law? Ordinarily, you would assume that if you say the lex cosia is the law of statewide, you have answered all the questions you need. But some of the time, you look at the law of statewide from 2 different perspectives. The law of statewide that the court of statewide will apply in purely internal circumstances, that is when the matter does not have foreign element, it may be different from the law of statewide that the court of statewide will apply when the matter has foreign element. Every country has a conflict of laws. Okay? At the introductory level, we told you that the subject is only called international because of the facts, the cross-border nature of the dispute that would attract reference to this subject area. That's why we call it international. Otherwise, the norm, that is the rules, whether of jurisdiction or of choice of law or of enforcement of foreign judgment, are part of the municipal law of every country. Okay? Yet, the court of a country might, in applying its conflict of laws, arrive at a conclusion that the governing law of a dispute is a foreign law. On other occasions, it might arrive at the conclusion that it is the internal law. So, when you say the foreign law governs the matter, what is the meaning of foreign law? Is it the internal law of the Lex Corsia, or is it the conflict of laws of the Lex Corsia? Okay, is it the internal law of the Lex Corsia, or is it the conflict of laws of the Lex Corsia? Let me give you an example. The most common example is, let's use Nigeria and Benin Republic. Benin Republic is a civil law country. So, if a matter borders on personal status and there is a foreign element, Benin Republic will use nationality. But Nigeria will use domicile. Suppose you have two people disputing the right to inherit, and whilst they are domiciled in Benin Republic, Nigeria is their nationality. If a case we have to come up in before the High Court of Lagos State, okay, because of the foreign elements, the High Court of Lagos State, in determining applicable law, would apply lex domicili, law of the place of domicile of the propositors, and that would be Beninese law. But what is Beninese law in that context? Beninese law in that context could be the internal law of Benin Republic. It could also be the conflict of laws of Benin Republic. Now, when you treat Beninese law as conflict of laws of Benin Republic, you will find that you might end up applying Nigerian law. Why? Because if you take the whole of Benin Republic law, including a conflict of laws, you will see that this type of situation, Benin Republic would rather apply the law of nationality of the propositors, which you have found to be Nigeria. Okay? So, sitting as a Lagos court, applying Nigerian conflict of laws, you have been directed to apply Benin Republic law as the Lex Corsia. If you take Benin Republic law to be just the internal Benin Republic law, your inquiry ends and you will apply Benin Republic law that the Benin Republic court will apply in purely internal circumstances. But if you take Benin Republic law to include its conflict of laws, you will then note that under Benin conflict of laws, under our choice of law rule, this dispute will be resolved by the lex domicili, law of the place of domicile. And it will then mean that, law of lex patrie, law of nationality. It will then mean that the Beninese court will refer the matter back to Nigeria. So that reference is what we call RUVA. So there are three RUVA theories, or there are two basic RUVA theories. The second one is subdivided. The first RUVA theory is rejecting RUVA. The other name for this is internal law theory. Internal law theory. The meaning is that when the High Court of Lagos, using Nigerian connecting factor, found Beninese law applicable, the court will reject RUVA and apply the internal law of the Republic. So the second broad category is accepting RUVA. If the court accepts RUVA, then the court would ignore the internal law of the Republic, and find its conflict of laws. Then the court will find that Benin Republic's choice of law rule is law of nationality, and Nigeria is the nationality of the propositors. So a Nigerian court, in the guise of applying Nigerian conflict rules plus Nigerian RUVA concept, okay, which is accepting RUVA, might end up applying Nigerian law in that context. Not because we are ignoring the foreign element, but because we are applying the conflict rules of the lex Kosia, that is Beninese law. Okay? Is it clear up to this point? The difference between rejecting RUVA and accepting it. You reject RUVA or you apply internal law theory when you just apply the internal law of the lex Kosia. That is the law of the lex Kosia that the lex Kosia court would have applied in purely internal circumstances. That means you reject RUVA. On the other hand, you are deemed to have accepted RUVA when you ignore the internal law and go for the conflict of laws of the lex Kosia. So that if by his conflict of laws, by his own connecting factor, it is another country's law that ought to apply, you go on and apply that country's law. So you are accepting RUVA. So I take it that the distinction between accepting RUVA and rejecting RUVA is understood. I now go to the other stage. There are two types of accepting RUVA. There is the partial RUVA and the double RUVA. What is the partial RUVA? In the partial RUVA, you have RUVA by remission, partial RUVA by remission, and partial RUVA by transmission. In the example we give, suppose both parties were, suppose the propositors was a Nigerian national, and we are asking of the conflict of laws of the Republic. And conflict of laws of the Republic say, in those type of situation we should apply the law of the place of domicile, the law of the place of nationality. And the propositors was a national of Nigeria. The Nigerian court, in following that remission, we now apply Nigerian law. But it is also possible that the disease was not even a Nigerian national. Suppose he was a Ghanaian national. And upon asking of the conflict of law rules of the Republic, you discover that it is the law of nationality of the disease that ought to apply. You will now follow that direction to go and apply the law of a third state, say Ghana, which is the nationality of the disease, or which was the nationality of the disease. When you do that, what you have done is that you have accepted partial RUVA by transmission. That is, the lex Kosia transmits it to a third country, and you apply the law of that third country, because that's what the lex Kosia's conflict rules direct you to do. So we call these two examples of partial RUVA. Partial RUVA by remission, partial RUVA by transmission. Then the second type of accepting RUVA, very technical, is what we call double RUVA. The other name for this one is the foreign court theory. The foreign court theory. What this one says that the foreign court should simply do is to assume that it is lifting itself, lock, stock, and barrel, and situating itself in the Les Corsair, do exactly as the Les Corsair court will do. Do exactly as the Les Corsair court will do. So somebody did a mathematical analysis and said it's simple to understand. In rejecting Ruva, you apply the internal law of the Les Corsair. In partial Ruva, you apply only the complete rules of the Les Corsair minus its Ruva concepts. But in double Ruva, you apply not only the complete rule of the Les Corsair, but its Ruva concepts. That means you are doing exactly what the Les Corsair court would do. This is the one that is usually a bit difficult to understand. But if you look at it from the perspective of, look, don't just apply complete rules of the Les Corsair. If you apply just the complete rules of the Les Corsair, you will end up doing partial Ruva by transmission or by remission. You must also apply the Ruva concept of the Les Corsair if you are going to do double Ruva. So, the Nigerian court, sitting in that example that I have given, after finding that the conflict of law rules of Benin Republic would direct the dispute to be resolved by the law of nationality, which is either Nigerian or a third country's law, it will now ask that assuming Nigeria or third country, assuming Nigeria or the third country would return the matter to Benin Republic, what would Benin Republic do? That would now depend on the Ruva concept of Benin Republic. If Benin Republic is a rejecter of Ruva, it will not accept that remittance back to it. It will instead apply Nigerian law. So a Nigerian court will end up applying Nigerian law because the Ruva concept of Benin Republic rejects Ruva. If on the other hand, Benin Republic would rather apply Benin Republic law based on the remission from Nigeria, a Nigerian court will also apply it because that is the Ruva concept. That's what the Ruva concept of the Republic entails. Okay? So that is double Ruva, otherwise known as falling court theory. Okay? It is the one that is greatly criticized in the sense that it cannot work if the Les Fora and the Les Corsair are both double Ruva territories. Somebody calls it international table tennis. That you just keep pushing and pushing to yourself. It's only by default that the egg would bounce twice on one side of the table. Okay? So that's the only condition for. Now you go and read Professor Agbede's Themes on Conflict of Laws. He has a chapter on Ruva where he criticized Ruva concepts. He also analyzed the reason given by English judges or English intellectuals for following Ruva. One of the most common reasons is that conflict of laws intellectuals will say that Ruva is necessary in order to promote uniformity, so that the forum at which a matter is decided will not I mean, the final resolution of a dispute would not depend on the forum at which it is filed. Okay, but Agbede would criticize that and say that it doesn't work, especially as you can see, if both the lecturer and the lex corsair adopt the same RUVA concept. Okay? And they will tell you that there are some subject areas where RUVA does not operate. For example, there is nothing like RUVA in the area of law of contracts. But RUVA generally operates in subject areas of personal status, like capacity to marry, formality of marriage, succession, and what have you. But it is generally not applicable in some subject areas. Okay? And the most difficult part of it is analyzing the cases. You will find that most English texts will tell you that the RUVA concept of common law countries is double RUVA, and they will use cases to illustrate for you. We don't have time. Go to your textbook and read the cases they are illustrating and see whether you agree with them that that's what they truly were doing or not. Okay, one of the cases that I think Collier and Rivers, something like that. That case was analyzed by somebody to say it is not double RUVA that they apply in that case. There is not double RUVA. They apply in that case after analyzing it. But most textbooks will present it as evidence that it is double RUVA that the English courts are doing. So let's leave RUVA on that note, and let's take the two presentations of today. Exclusion of otherwise applicable foreign law and domicile. Thirty minutes. I will discuss both topics in the first 30 minutes of next week's lecture before we start marriage.
Good evening, Prof.
Yeah,
Sir,
good evening.
The topic exclusion of otherwise applicable foreign law was divided into two different groups. The simpliciter and the one that...
Two of them we just present in 15 minutes.
Okay, so for group 9, we are presenting the part that has to do with failure to plead or prove. So we'll quickly run through our group members. Collins Mbakwe, myself, present. Follow Runshaw Ayobola. Are you there?
Present.
Kuroso Yinka Barisi.
Present.
Daniel Lawson.
Present.
Tohib Kowojue.
Present.
Joseph Blessing.
Present.
Shola Mujid Oluwafemi.
Present.
Julius Ghana.
Present.
Okay, so Prof, our paper is divided into 5 parts. 2 people will present in our group. That is Mr. Daniel Lawson and Joseph Blessing. Daniel will present the first part, that's abstract part 1 and 2, and then Blessing will present parts 3 to 5. So I'll yield the floor to my colleague, Mr. Lawson.
5 minutes. They should talk to their topic in 5 minutes, please.
Okay, Prof. Good evening, Prof. Good evening, everyone.
Good evening.
Basically, our topic, as earlier introduced, is exclusion of otherwise applicable foreign law. We're looking at failure to plead or prove. So our paper looked at the doctrine and made examinations of failure to plead or prove of foreign laws as a procedural ground for exclusion of otherwise applicable foreign law, especially in Nigerian private law. So although Nigerian choice of law rules may designate a foreign legal system as the Lex Casal, its application is contingent upon strict compliance with evidential and pleading requirement, which is basically derived from the English law. Now, we looked at the orthodox position, which is that the foreign law is treated as a question of fact rather than law. We said it must be pleaded and it must be proven, and is in line with Los Mansfield's position in Mustin versus Fabregas. In Mustin versus Fabregas, in that case, Mustin was an indigene of an island, the Monoka Island, and he instituted action against Fabregas in England. The simple fact of the case was that he instituted action against unlawful arrest, assault, and he was banished to Spain, an island in Spain, Cartagena in Spain. Now, he brought an action against Fabregas, who was the then governor in Monica Island in England. And the question was whether the court in England had jurisdiction to hear the matter between two indigenes of Monica Island, wherein one was the governor. In that matter, Lord Mansfield ruled that the court had jurisdiction to hear it, and cited an edict relying on an edict that had in some time assigned a part of the island showing ownership to England, and relied on the fact that what amounts to a crime in island of Monica, when looked at in England, is not a crime in the Monica Island. But in England, according to the laws of England, the offense of the assault is a crime, because Fabregas was the governor, and for you to sue the governor, you need consent of the governor. And the argument was that the offense Mustin was accused of is not an offense known to the island of Monica. So, but under the laws of the English laws, it was held to be an offense, and so the court entered judgment in favor of Mustin and gave award. So the court also ruled that you can, in that case, Lord Mansfield held inter alia that the court must take judicial notice of foreign law, especially when it is evidenced. So basically, our argument is the rule, as we look at in Nigerian position, reinforces the adversarial model of placing responsibility on the litigant, meaning that the litigant has to plead and prove, wherein to state that applying a foreign law will better aid his case. So the position of our laws moves the responsibility to the litigant. And our courts have severally held in plethora of matters that foreign law must be expressly pleaded and proven in line with the Evidence Act. We also looked at a case, Pinnock Investments Limited versus Hotel Presidential Limited. Briefly, in that case, Pinnock Investment Limited had their office, registered office in Enugu, as well as Hotel Presidential, but they brought an action against Hotel Presidential in Anambra State. And the subject matter was payment of rents and mensing profit for a property situated in Port Harcourt, Rivers State, which Hotel Presidential has leased as an annexure to their hotel. In that case, Hotel Presidential relied on Edict 17 and 15 of Rivers State, wherein Rivers State had cancelled every lease of land between the state and persons, being that the law had moved. There had been a proclamation, and it had moved from the in the English, the Eastern laws that was then in power, because it was 1967. So all of those places were looked at as Eastern region. But when it was promulgated and River State came to be, River State now made an edict cancelling all lease on areas. So the Hotel Presidential relied on the edict and said they were not entitled to pay rent and mention profit because the property had been cancelled, or the lease on the property had been cancelled by the edict of River State. The Supreme Court held inter alia that, when looking at the case, stated that the action of the River State amounted to a breach, as they cannot make a law to cancel a lease that had been duly entered with the Eastern region when it was the Eastern region. However, the Supreme Court said that the River State was not a party to that suit, and that in the light of the fact that they have cancelled the lease, they ought to pay compensation to Pinnock Investment. Although Pinnock Investment had claimed that River State government was interested in the property and had approached them to sell before, and they refused to sell. But the court held that Pinnock Investment, although was entitled to payment of rent for the period of 1967 to 1970 before River State made the edict. However, that they were entitled to compensation from River State. So that was the decision of the Supreme Court in that case. Also, we looked at the case of Ogunro versus Ogedengbe. It's a succession case, and the party had brought an action to determine whether the High Court could make pronouncement on properties, immovable properties that were in Ghana. In that case, the properties of Ogunro was in Nigeria, and some immovable property were in Ghana. So when the administrator of the estate approached the court, the court held that in as much as it has jurisdictional authority over the parties, meaning the plaintiff and the defendant, it had jurisdiction over the both parties. Definitely, it was in right to be able to share the property in Ghana. That was what the court held in that case. This is section part one of our paper. So we, in all, what we are saying is that the orthodox position is that our laws treat foreign laws as a question of fact, and you need to plead it and prove it for it to be relied on. In our part two, we did a comparative context study where we looked at what is the position in UK as against our position in Nigeria. So in UK, we were able to see that the right, it was not as traditional, or the rule was not as rigid. The position is not as rigid as it is in Nigeria, in as much as we are following the traditional rule from English law, which emanated from the case of Mustin versus Fabregas that we had earlier discussed. The UK position is that they operate a sort of hybrid position where justice is kind of the watchword. So they are more justice inclined rather than relying on judicial technicalities. So they operate a hybrid system wherein they entertain foreign laws, especially when it has been evidenced, it has been proven, and it will amount to injustice if it is not applied. So also we looked at US, what happens in the United States position, especially as regards the application of foreign laws. And we discovered that in the US, they have a rule 44(1) of the Federal Rules of Civil Procedure. This, which actually makes foreign law to be treated as a law. So foreign law in US is actually treated as a law, not as fact. In US, the judges are at liberty to carry out research, a wide range of research. So here we can actually see autonomy, where the judge, a particular judge, is at liberty to carry out research on a particular foreign law beyond what has been pleaded in a bid to carry out justice. Basically, we also looked at the fact that in US they have what they call a full faith credit law that makes it easier for judgments in other states of US to be applied in every other state without recourse to procedural hiccups. So we were able to look at all this case law, also as well with the case of Osagie versus Oyeyinka. And in all, we came to a conclusion in our chapter 1 and 2 that in line with the old English position before they moved to hybrid in England, which we still maintain, is that for a foreign law to be applicable, it must be pleaded and it must be proven. And where it is not pleaded or proven, it does not go to affect the case. The law of the lex ferri will definitely then apply as though it is the foreign law. Thank you, sir.
Thank you. Do you have any authority for that? The position that failure to plead or prove.
Yes, sir.
Does not mean that case is lost. It only means that foreign law will apply.
Yes, sir. The case of Osagie versus Oyeyinka, sir.
Okay.
And the case of Lawal versus Daudu.
Okay.
Where it says that the court cannot sumo to apply foreign law.
Okay. So the next part now. Is there any?
Yes, my colleague is taking the other part, even though. Yes, go ahead, Madam Leslie.
Good evening, Prof. Good evening, class.
Yeah, good evening.
Yeah, so drawing from what my colleague has already taken, he has already taken the position of the UK and the US. So drawing from those the study of those doctrinal positions, we found some reform proposals and reclassification that Nigeria may need to undertake. One of which is the fact that Nigeria being rigid and based on its position that foreign law should be treated as a question of fact is currently too rigid, and there is a need for a change or modernization or reclassification of that position. And as such, Nigeria can demonstrate its readiness to move away from that rigid position by undertaking a full reclassification of that position, that is moving from treating foreign law as a question of fact to treating it as a question of law, as is obtainable under the United States position. Or it can go through the approach of the hybridization, which would entail that Nigeria would primarily remain look at foreign laws as a question of fact, but still in some circumstances it will supplement by allowing those laws to be applicable even where they have not been proven
or pleaded.
Also, drawing from the study, we realize that there is the need for these innovations or changes because of the current modernization and global trends when it comes to high standard of contractual obligations and litigations when it comes to some forms of in areas like telecommunication, energy, and such kind of contracts. Then it would be rigid and evade justice for Nigeria to continue to apply its current position when it comes to foreign law. does, there are some procedural innovations that Nigeria can look into, which is one, that there should be court-appointed experts. So it shouldn't just wait for parties to plead and prove the foreign law. The court itself can appoint experts, especially in cases where parties are contradicting each other on the position of that foreign law. Also, that court can also ensure that parties come together to appoint a joint expert. Also, Nigeria can look into the issue of pretrial determination of foreign law. That means that at the level of pretrial, before the matter goes to trial, the parties would sit down to decide and bring the law into the preliminary matters that with regarding to those foreign laws, such that when it gets to the stage of trial, they wouldn't have to go back to begin to try to prove or plead those matters. If some issues that parties have been taken care of there is the need for legislative reform, especially with regards to amending the Evidence Act, in regards to Section 68 to Section 70, because those provisions of the law do not really address the unique status of laws, and also it does not provide guidance on how the judiciary can be engaged in these foreign materials that are provided in proving the foreign laws. When Nigeria's position, we say, is when the foreign law is not proved, then you revert to the presumption of similarity. Such kind of situation erodes justice, because you cannot presume that the foreign law is the same as that of your country, and ultimately parties might not get the justice they want, and it's
Hello.
Such situations, it will make Nigeria, it will lowering judicial resolution to the conclusion that Nigeria should. Hello.
I'm hearing you.
So we came to the conclusion that Nigeria should transition towards a functional and pragmatic model, not the traditional rule, which is a bit rigid. And thus, the new approach should be characterized by judicial flexibility, allow the judiciary to have autonomy and independence when it comes to application of foreign laws, just like it's seen in the case of the United States. And as such, it will kind of reduce the rigidity that comes with the procedural current position, and thus there will be emphasis on more of substantial justice. That way, the position is not entirely abandoning the traditional principle, but it's actually being flexible to bring in a new approach that would be more suitable for the contemporary position. Then also the fact because Nigeria has used this approach all the while, it cannot radically transform from the traditional rule straight up to a new rule. Thus, it is suggested that the transformation or transition should be a form of incremental reform, which will start with hybridization of foreign law being a question of fact and a question of law. And finally, that excluding foreign law for the failure to plead or prove is not just a technical rule, but it is a structural feature of Nigerian adjudication, and there is a need for reform. It is because it is inevitable based on the current trend and the fact that the world is moving towards a global world, and as such, only then can it be said that Nigeria is responding to the demand for an increasing interconnected world, a world where one could feel that, okay, they will always have justice irrespective of wherever it is that the matter is being adjudicated. Thank you.
Okay, now let's take the other group. You have 15 minutes.
Good evening, sir. Good evening, everyone. So this is group 11. We are presenting on exclusion of otherwise applicable foreign law, penal or revenue law, and when foreign law violates foreign public law. The group members are Ogun Kelu Tomilola Olaide,
Present.
Okere Omotayo, Oloyede Abdul Mojid,
Present.
Olaiwola. Thank you. Olaiwola Tolulope,
Okere
myself.
Omotayo is present, please.
Thank you, ma'am. Oluwasomi Iyanuoluwa Deborah and Omi Unu Blessing Ayobami. Apologies for the wrong pronunciation. Okay, so
I'm present.
Thank you very much. So going into our presentation, we're going to be taking it in 4 major parts. The introduction and conclusion will be taken by Okere Omotayo. The part 2 on general principles of applying foreign law will be taken by Oloyede Abdulmojid, and I will be taking exclusion of foreign penal law and revenue laws and foreign law and foreign public policy. So, Mrs. Omotayo can start. Thank you.
Thank you, Tolulope. So I'll just leave and go straight to the introduction, which is our part 1. So we're talking about the importance and significance of foreign laws on the development of states, which has been analyzed and vindicated in numerous studies in legal literature. So it's a major trend that has even been increasing the volume of references to foreign law in court rulings worldwide. So as it's common knowledge today, foreign law plays a key role in determining the success or otherwise of international transactions. So we have made an attempt to talk about it in our papers. So we want to talk about the definition of foreign law. Foreign law has been said to mean the law of a state, including the law of a territorial unit of a state, so other than the foreign state. In simple terms, this refers to the domestic or national laws of a foreign jurisdiction. So this could also extend in some instances to the law of an identifiable group of foreign countries that share a common legal system or a common set of rules in a particular field of law. So the foreign law of a particular nation state defines the relationship within its borders. So the most important primary sources of foreign law will depend on the type of legal system, but we often include constitutions, statutes, regulations, and court decisions of each country. So we're talking about foreign law and conflict of laws. Talk about private international law or the conflict of laws is that branch of a municipal legal system which comes into operation whenever a court is seized of a dispute containing one or more foreign elements. So the fundamental task of conflict of law is to select the most appropriate legal system to govern the dispute and thereafter to apply it. So once applicable law is identified through the forum choice of laws rules, whether the lex loci contractus, the lex loci delictis, the lex citos, the lex domicile, or any other connecting factor, the forum court is in principle obliged to apply the law as it will be applied in its own country of origin. So yet the obligation to apply foreign law is not unconditional. So every legal system reserves the right to withhold application of a foreign law in defined circumstances. So two such circumstances are of particular importance and constitute the subject matter of this paper. So the first is the penal and revenue rule. The second is a public policy exemption. So both doctrines operate as a boundary between deference to foreign law, that is committee, and assertion of the foreign's own sovereign rules. So that is our introduction. So my colleague will take the part 2, the general principle of applying foreign law. Thank you.
Hello,
good evening. Hello, good evening, though.
Yeah, good evening.
Yes.
So I'll be taking the part 2, how foreign law is pleaded and proved in Nigeria. So that's the part 2. So in Nigeria, foreign law is a question of fact and not of law. A party relying on foreign law must plead and prove it in accordance with the Evidence Act. It is usually done through the calling of expert witness, because the position is that he who asserts must prove, and in proving foreign law, 2 key issues are applicable. You can either prove foreign law by calling expert witness or by tendering official documents in proving foreign law. Going forward, it is straight law that improving foreign law, it is straight law that improving foreign law when, sorry, excuse me. Okay, it is straight that when foreign law is not pleaded and proved, the court will generally apply lex fori, that's the law of the state, as if the foreign law is the same as the law of the forum. That simply means that when proving foreign law, when it is properly proved, the court will just interpret it as if it is the domestic law of that region. So we have also looked at the Supreme Court case in Pinnock versus Hotel Presidential. Our colleague in Group 9 already gave us a brief of that Pinnock, the Pinnock case. So in also looking at the doctrine, we observe the position of Clarkson and Hill in their book. They have observed that the obligation to apply foreign law is one that every legal system qualifies in important respect, and that the exception of general rule of application are just as much as a part of private international law as the rule itself. So what Clarkson and Hill was actually saying in their book is that foreign law is one that in every jurisdiction, is a position in every jurisdiction that sorry please, my notes are confusing.
Okay, sir. Let me just go to the next chapter then. So that
hold on, please. So we look at the doctrine of comity, because that's where I ordinarily ought to have started. I'm sorry about that. Doctrine of comity is a principle of international law that recognizes the importance of showing respect and deference to the laws of a foreign jurisdiction, simply a matter of international courtesy and practical necessity. So that was when we now look at the Clarkson and Hill position. So we talked about the exception to the general rule of application. It is pertinent to note that comity is not a rule of law, but a principle of mutual respect and convenience. This is significant because comity is not obligatory. The overriding interest of the forum state will be taken into cognizance by a court in deference to foreign law. Also, Westake also opined in his book that the application of foreign law is not a matter of obligation, but of comity, and comity ceases when it begins to be contrary to public policy, which means that the public policy of that forum state is also very, very important, and at times will be taken into cognizance when applying foreign law, the public policy of the forum state. So we also looked at the Nigerian courts, the reaction of Nigerian courts and foreign law. it is the presumption that the court is blessed with having all local laws at our bosom. In the issue of foreign law, this is not applicable because it is expected that foreign laws must be pleaded and proved. So it is not deemed that, oh, the court understands all the foreign law, unlike our local law. So in proving that, the burden of proof lies on the party asserting the foreign law. And the proof can only be established in two ways, which is calling of expert witnesses and also tendering of official documents, as we have highlighted earlier, in compliance with the Electoral Act, we compliance with the Evidence Act 2011. So we also look at the exclusions. The justification of retaining exclusionary doctrines alongside the general obligation to apply foreign law rests on the several converging considerations. First, the territorial principle holds that certain categories of obligation, particularly those arising from states' sovereign power to punish or to tax, are inherently local in their nature and cannot travel beyond the borders of the enacting state, meaning that at every point in time, local laws are meant for a particular state, and in applying it in other foreign states, other things must be put in place before these foreign laws can take effect in other states. We also look at the case of Kuwait Airways. In Kuwait Airways, it is also applicable. Foreign law was actually used in Kuwait Airways. Also in Olojo versus Olojo and Societe Generale Bank versus Walker, where the court established that once foreign law is properly proved, then it will be deemed as if it was interpreted as the local law. Thank you. So I'll hand over to my colleague to take the chapter 3.
Thank you, sir. So going straight to the exclusion of foreign penal and revenue law, it's well established that the courts have no jurisdiction to entertain an action for enforcement, either directly or indirectly, of penal, revenue, or public law of a foreign state. This was well established in the case of Her Majesty's Attorney of New Zealand and Otis, and in the context of revenue law in the case of Poiliot and Ogden. Similarly, in the case of Hunting and Attrill, it was well established that the foundation for the enforcement or punishment of crimes is tied to the breach of public law, which is punishable under a particular state's jurisdiction. Accordingly, no proceeding, even in any shape of a civil suit, which has for its object the enforcement by the state, whether directly or indirectly, of punishment imposed for such breaches by lex fori, ought to be admitted in courts of another jurisdiction. So basically, the courts have held that the courts of no country would execute the penal laws of another. And this is one of the reasons why foreign law can be excluded under this subheading, which is where conflict of law rules have pointed to the application of a penal law that has been, of a foreign penal law. The lex fori can decide not to apply such laws on this basis of the fact that another sovereign should not be enforcing the public law or the criminal law of another sovereign. The question has arisen as to what the definition of penal law is and who defines penal law. It has been established that penal law is defined by the lex fori, and this was affirmed in the case of Hunting and Attrill, where the court emphasized that the classification of a foreign law as penal is exclusively a matter for the forum court. Another method was also established in the case of USA and Inkley, where the US government sought to enforce a Florida judgment in England. the English courts established or went into a threefold inquiry to decide whether or not to enforce such law. It asked whether the law primarily benefits a foreign government, whether the law's purpose is to impose criminal sanctions or maintain public order, and whether the remedies sought indicate a penal rather than a compensatory aim. Similarly, in the case of Restate of Norway applications, it was recognized that enforcing a foreign penal law has been viewed as potentially assisting another state in exercising its foreign authority. As such, foreign courts are typically reluctant to act as agents for implementing the penal sanctions of another country. So I'm just going to go straight to the exclusion of foreign revenue law. It was established in the case of Ullman and Johnson that no country ever takes notice of the revenue law of another, although this argument or this proposition has been recognized as too widely stated. A more limited application of the rule was in the case of India and Taylor. And the reason for the non-enforcement of foreign revenue laws is that tax gathering is not a matter of contract, but of authority and administration between the state and those within its jurisdiction. As such, another state will not enforce either the penal revenue or public law of another state, either directly or indirectly. And this is also grounded in the concept of sovereign equality, which holds that the laws of one state, particularly those relating to revenue collection, should not be enforced within the jurisdiction of another state. However, there have been various arguments as to the difference between recognition and enforcement. In the case of Regazzoni and KC Sethia, it was held that it does not follow from the fact that today the courts will not enforce a revenue law at the suit of a foreign state, which requires the doing of an act in a foreign country, which violates the revenue law of that state. The two things are not complementary or coextensive. For an English court will not enforce a penal law at the suit of a foreign court, yet it would be surprising if it would enforce a contract which requires the commission of crime in that state. So basically, this was a critique of Lord
public policy.
Yes, sir.
I said that one will come under public policy now. Do you understand?
Yes, I
do. Go ahead. I was cautiously just interjecting.
Okay.
Well, we will discuss everything next week.
Okay, sir. Thank you. The correct principle. Okay, so this was a proposition that sort of critiqued Lord Mansfield's position that no country ever takes notice of the revenue laws of another, as it was widely stated. The correct principle should be one of enforcement and not recognition, whether neither direct nor indirect enforcement of a foreign revenue claim is sought. The court may recognize the existence and effect of a foreign law, even though it will not enforce it. So we quoted several cases in our paper, Government of India and Taylor, where the House of Lords squarely held that a foreign state could not recover from the English courts taxes owed to it by a company wound up in England. The lordships affirmed that revenue laws of one state have no operation of their own in another state. In Regazzoni and KC Sethia, the court further established that a contract for the performance of which involves a breach of the revenue laws of a foreign friendly state will not be enforced, even though the action is not one for the enforcement of the foreign revenue law itself. Also, in the case of Brockham and C-Train UK Limited. So I'm just going to go to our chapter 4, which is foreign law and foreign public policy. It is noted that in various systems of law, even in Nigeria, the court usually retains the power to refuse to enforce laws that are contrary to public policy. As such, it also applies that where the conflict of law rules points at the application of a foreign law that is contrary to public policy, the foreign court has the power to decide not to enforce such a law. This rule was clearly stated. English courts have no jurisdiction to entertain an action for the enforcement, either directly or indirectly, of a public law that is contrary to public policy. In the case of Kuwait Airways Corp and Iraqi Airways, the case concerned the seizure by the Iraqi government in the aftermath of Iraqi's invasion of Kuwait of aircraft belonging to the claimant company and the effect of an Iraqi government resolution transferring the ownership of the aircraft to the defendants. The court in that case held that that a provision of foreign law will be disregarded when it will lead to a result wholly alien to the fundamental requirements of justice as administered by the foreign court, in this case, the English court. The court held that a result of this character would not be acceptable to an English court. So basically, in this case, the court refused to apply foreign law because it was contrary to the public policy of the English courts. Similarly, in the case of Grell and Levy, the English courts refused to enforce a foreign gambling debts on the grounds of public policy. There are different tests that apply for invoking public policy. One of those tests is the repugnancy standard. In the case of Kaufman and Justin, the Court of Appeal refused to enforce a French contract under which a wife had agreed under duress to pay a sum to suppress a criminal prosecution. This agreement was actually valid under foreign law, but was held contrary to English public policy because it involved stifling of a persecution. Similarly, in the case of Veraveke and Smith, Lord Simon stated that public policy exception applies where the foreign law's application will be so grossly offensive to the English court's perception of judgment that recognition or enforcement is unconceivable. Similarly, in the case of E.M. Lebanon and Secretary of State for Home Department, the House of Lords considered whether to apply Lebanese family law, under which custody automatically reverted to the father, and it was held in this case that it would violate Articles 8 and held that it would constitute public policy for non-application in appropriate circumstances. This is as relates to a law that infringes on the rights on human rights. There are various cases. In the case of Oppenheimer and Katamol, the House of Lords refused to recognize a 1941 Nazi decree that stripped German Jews of their citizenship and confiscated their property. It was stated that the law was so grave an infringement on human rights that the courts of the country ought to refuse to recognize it as a law at all.
Very well.
So as it relates to Nigeria, so we have in our paper, we have various cases that we have cited. There are quite a number of them, but
we will look at them. We will look at them, please.
Yes, sir. So just to bring it, okay, sir. So just to bring it home to Nigeria, in the case of National Insurance Corporation of Nigeria and Power and Industrial Engineering Co. Limited, the Supreme Court recognized that Nigerian courts would refuse to enforce contracts whose performance would violate Nigerian public policy. Similarly, in the Arbitration and Mediation Act 2023, sections 55(3) BII provide that an arbitral award will not be recognized in Nigeria if to do so would be contrary to public policy of Nigeria. So it's abundantly clear that as much as we have numerous...
What section did you cite?
So that is the Arbitration and Mediation Act 2023.
What section?
Section 55(3) BII.
No, I think it's section 58. Section 55 is on setting aside of arbitral award. It's section 57 and 58 that are on refusal to recognition and refusal to recognize. And it is, I think it's section 58 specifically that set out the grounds upon which the court will refuse to recognize. And that particular one you are talking about is also included as one of the grounds. That is, if the award, the tenure of the award is contrary to the Nigerian public policy. Okay?
Yes, sir. Yes, sir. Yes, sir. Thank you, sir. I just quickly checked and I saw that you are correct, sir. It's section 58, and we'll correct our paper accordingly.
Mm-hmm.
Yes, sir. So on this note, I think I can come to a conclusion as relates to public refusal to apply foreign law that's contrary to public policy. And I'll hand over to my colleague to give the conclusion.
You are still handing over?
It's for the
Today
conclusion,
we wanted
sir.
to take domicile today. Oh, God.
It's less than 2 minutes, sir.
Okay, conclude. Let your colleague conclude in 2 minutes.
Thank you, sir.
Thank you, sir. So in our part 5, the conclusion. So our paper has examined 2 key doctrines that limit the application of foreign law, and 2 of them, the penal and revenue law and revenue rule. So the penal and revenue rule prevent court from enforcing foreign criminal laws or tax claims, reflecting state sovereignty. So courts independently determine whether a law is penal, as established in cases like Government of India versus Taylor and Alton versus Atray. So the public policy exemption allows court to refuse foreign law where it violates fundamental justice or moral standards. However, it must be applied narrowly, as emphasized in Kuwait Airways Corp versus Iraq Airways Company. So in Nigeria, these doctrines are evolving through legislation like the Arbitration and Mediation Act of 2023. So the Constitution of the Federal Republic of Nigeria and international obligations. So overall, why these doctrines are necessary, they must be applied carefully and with restraint to maintain fairness, predictability in cross-border disputes. So summary, this paper, it proposes 5 key reforms: codification, judicial clarity, judicial training, treaty expansion, and human rights focus. Codification: Nigeria should enact comprehensive private international statute to clearly define.
We will read your recommendation, please.
All right, that will be all. Finally, so the conflict of laws. Finally, the conflict of law seeks to balance respect for foreign legal system with protections of domestic values. So Nigerian courts must apply these exceptions prudently, ensuring they are not misused to avoid foreign law, but instead serves as principled safeguards in international justice. Thank you, sir. That will be all for our paper.
The domestic group, can you start?
Hello, sir. Good evening, sir.
Yeah, good evening.
Yes, sir. Sir, I wouldn't want to waste the time of the group chat. So, for the sake of it, I will just adopt every group member's name that is on the paperwork. We are 18 numbers, and that is it. So, in our topic discusses personal connecting factors in the conflict of laws, which include domicile, nationality, and habitual residence. Which includes domicile, nationality, and habitual residence. Our work generally just deals with the determination of a person's applicable personal law as a central challenge in modern conflict of laws. And our paper undertakes the comparative examination of 3 personal connecting factors, which deals with domicile, nationality, and habitual residence. And our study focuses on the traditional foundation of domicile, its common law tradition with different classifications, be it domicile of origin, choice, and dependency, nationality as a connecting factor, and the cornerstone of civil law system, and also exploring theoretical ground in the work of scholar Mancini and its operational characteristics and dominance of habitual residents, particularly with the Hague Conference instruments and the EU regulation as a flexible, fact-based alternative, better suited to contemporary realities of migration and integration. So we begin, sir. What is domicile? As we are all aware, domicile deals with where you were born. Domicile ordinarily refers to the home country of a person or where a person plans to live, or a country where he or she plans to live indefinitely and permanently. Domicile is just a connecting factor to persons dwelling in a place and establishes and identify their oneness. So what do I mean? What I mean is domicile is a fixed and permanent home where a person lives and always plan to return to. Then the question of domicile is mostly arising to know the legal status of a person when he or she is traveling and which jurisdiction will be relevant, be it marriage, divorce, legality of a contract, and other legal matters. As we are aware, domicile combines residence with the intention to reside indefinitely. This classical formulation appears in the case of Udny and Udny, and domicile is a common law concept. The main rule of domicile are categorized into just 5 doctrines which are governed by the case of Mark and Mark, and they state as follows. Everyone is attached to a domicile which is known as the domicile of origin, because as you are born, you have a domicile. As you live in a place, you have a domicile. Domicile also prohibits a person from having 2 domiciles simultaneously. He or she might stay in different states as residents, but his legal action will be governed under one jurisdiction. So, domicile is different from nationality because you can be a dual citizens of 2 different countries, but you can't be a domicile of 2 different countries. Then, domicile ties with one regional system, meaning it's a regional system that governs you. Number 4, everyone will presume that his current domicile will continue unless he or she plans to change it on the balance of probability. And lastly, in common law practicing countries, if there are no statutory exception, the identification of domicile is based on English common law. As we have in the case of R.E. Ansley, where it states that a British domiciled man was living in France. Then, when conflict of law arose about the domicile of the person, the court decided that is domiciled and established based on English law and the law of forum because he has always been a British man. So we have 5 types of domicile. We have types of domicile, which is just 3. We have the domicile of origin, we have the domicile of choice, and we have domicile of a dependent person. So I'll summarily just talk about domicile of choice, origin, and of a dependent person. Domicile of choice, a domicile of origin, as we know, it's gotten from the day you were born. It is gotten from childbirth, and this is achieved by the operation of law of the birthplace. And it could be domiciled of both your parents, because I won't have a domicile if I wasn't born into a family, or I can't come to planet Earth and not have a domicile. Then we have the domicile of choice, which is gotten by legal qualified adult individuals with genuine intentions to reside permanently in a particular place or particular state other than their domicile of origin. One can't just have a domicile of choice until maturity. In certain countries, they are able to choose their domicile of choice at the age of 18, some countries 16, and some countries 21. This indicates that the person willing to accept a legal system will follow indefinitely for the rest of his life, because once you choose where you want to be domiciled with, you ensure that you obey and comply with everything in that country. Then, as we have in the case of Mark and Mark, it involves the presence in a state as a bona fide member desire to establish their permanent and indefinite home. So that is what domicile of choice is about. And domicile of choice is just dividing it into two ways. We have the objective test of dwelling and the subjective test of intention. Meaning, for me to choose Senegal as my domicile of choice, I must pass through the objective test, meaning one has the intention to remain in the dwelling place permanently, and the subjective test of intention to remain in the permanent place permanently. As we have seen in the case of IRC and Duchess of Portland, it states that residence in a country for the purpose of law of domicile is the physical presence in that country as an inhabitant of it, and an instant arrival with the intention to live permanently and sufficiently fulfilled the requirement of residents for acquiring a domicile of choice. And we have in the case of James Sloan and Sarala Davis Sloan, where the court states that in all circumstances, one must sufficiently establish that the applicant not only resided there, but also had intention to reside there permanently for an indefinite period of time. Meaning, even if I'm to go to another country, my intention must be that I must travel to that country and settle there for an indefinite period of time. Because when the court begins to question your authenticity or validity of your domicile in a state, they don't just look at you staying in a country, but they look at the intention to reside in that country for an indefinite period of time. Then we have the domicile of a dependent person. Domicile of this dependent person is assigned to individuals who lack legal capacity to choose their own domicile and or don't have the temerity to choose where they want to be domiciled. And it deals with the lack of legal capacity to choose their own and their own domicile. So let's assume I was born. The only domicile I have is the domicile of my father, who I am a dependent person. For example, when the domicile of principal is surrendered, the domicile of the of domicile of the dependent is automatically surrendered. By this rule, a child obtains two domiciles at his birth, namely domicile of dependency and domicile of origin. And under common law, a wife obtains husband's domicile and the children acquire domicile of their parents. And this type of domicile is divided into two. We have the domicile of a child and the domicile of a married woman. Meaning, like I said earlier on, as I'm brought to this world, under the domicile of a dependent, I have the domicile of my parents till I reach the age of maturity. And for married women, it is said that once you are married in different cultures, you choose the domicile of your husband. Then we have the strengths and weaknesses of domicile in conflict of laws. As we all know, domicile connects a person to the judiciary of a particular place. And this modern era, where people are moving around the world, wherever a person goes, his domicile of origin follows him unless he obtains a new domicile with the free intention to live permanently in a different country. The doctrine of domicile also provides a unique system to ensure a person is bound by a legal system.
My friend, I have to leave now. I'll give you 10 minutes to round up this discussion next week. Then I will use the remaining 50 minutes to discuss all the topics we discussed today. And we can use the remaining 1 hour to start our discussion on marriage. Okay? By the time we finish, we have marriage and the thoughts left. Okay?
Sir, if I may interject, sir, I think earlier you told us that thought and marriage, that will take that next session.
Okay.
No, you said thought. I know of thoughts. You said thought will be next semester.
I said I usually take either thought or marriage, but I don't know. When we come next week, we'll take a decision.
Okay, sir. Because my spirit is saying that if we take the 2 next semester, that maybe by next week or next, you will do revision with us and bless us.
Okay, well, let's see what happens. At least we will conclude this domicile that we have done.
Okay, sir. Thank you very much.
But I must leave now. All right, so I see you next week.
Thank you very much, Prof.
So, continue your discussion.
Yes, sir.
For another 10 minutes. I'm finished with domicile.
Okay, sir. So, we have disadvantages or weakness of domicile in conflict of law.
I say you will continue it next week.
Okay, sir. I'm so sorry.
Yes, I will give you 10 minutes to continue it next week.
Yeah, have a lovely night rest, sir.
Thank you very much, Prof.
Thank you, Prof.
Thank you, sir.
Yeah, you're welcome. Yeah.
Thank you, Prof. Thank you very much, sir.
Yeah.
Thank you, Prof.
Honorable, I cite you. Good evening.
Doctor,
I cite you.
Doc, I have a question for you. Doctor, I have a question for you.
I cite you.
Yes, please.
Doc, I have a question for you. You said your spirit is telling you.
Yes.
I know for a fact that you have 2 spirits. I want to know the spirit that is telling you, because I know we have 2 spirits. I want to know the spirit that is telling you, sir.
Okay, what is spirit A? What is spirit B?
You have the Holy Spirit and you have an evil spirit.
You are my evil spirit. You are my evil spirit.
I'm suggesting. Hello, class.
Hi.
Yes, hello, class rep. Hello.
I'm actually suggesting one thing. And if you look at past questions, right? And for those who have not read on marriage, if you look at the marriage itself, the topic is still more easier to answer in exam than some of the ones that we have seen, if you check past question. So instead of we pushing marriage, because marriage is something relatable, we have cases, it's still direct, so let's look at that. So let's just take marriage, and we can even appeal to Prof that marriage should even be part of the AOC is going to give us. So let's try. Don't let us go and be relying on all those that might give us.
As your lordship pleases, as your governorship pleases.
Very well. Class governor, very well.
I've spoken well.